Kirk is not an attorney. This is not legal advice. This is to be considered for educational purposes only.
Welcome to Kirk's Law Corner Live with your host, Kirk Pendergrass and Chris Hallett.
What's happening, everyone?
Good evening, folks. We're here. Kind of. Just to let you know, I started a temporary job right now, so I'm working 10 to 6 my time here in Mountain Time. So that's, noon to 8 Eastern Time. So we're having to change the times and having a hard time getting going because I don't get off until 8, and then I've got to drive 21 miles to get back home.
That's like 45 minutes.
Yeah. If I'm cooking it and traffic's going good, tonight was 37 minutes.
Yep, that's a change, that's for sure.
Yep. And most of it's freeway driving, so 65, 70 miles an hour.
How's the traffic in Boise?
Depends on which way you're going.
If you're going out of the city at rush hour, that's a long drive.
Yep. It's it could be an hour and a half to get what we have. We have Boise, and then we have like Nampa Caldwell area, and it seems like a lot of people move to the Nampa Caldwell area because the cheaper rent, but work in Boise. So
yeah,
it's like, and it's like Idaho's like seems to be behind the times when it comes to being up on things, especially like the amount of lanes of traffic that we need to support the amount of people we've had move into this state.
Mm-hmm.
I mean, they added the third lane on the freeway there, and then the following year tore it all back out again and added the fourth lane. It's like, what? I don't know. It just doesn't make sense around here. But we're bunch of rednecks back here. We grow some potatoes and feed y'all.
A little bit of this, a little bit of that.
And the gem state, we're also dubbed the gem state. So we have good old gems up there in the mountains. A little bit of gold. There was a gold rush here back in the day. It was 1845-ish, 1849-ish. That's what brought people here. So
they found them taters later on.
We found some of that plutonium nyborg.
Plutonium cyborg, huh?
Nyborg.
What's nightboard? I know what plutonium is, but not nightboard. What's nightboard?
What show was that from?
Knight Rider?
Plutonium nyborg left. It's out in space. It's kind of a cartoony one.
I don't know. The Clone Wars?
They break out the machine and start pumping the white powder and doing lines. They called it plutonium nyborg.
Oh, I don't know. No idea.
Oh, man. Nothing surprises me.
Spaceballs or something like that. Anyway.
Well, we are back, boy. It's been crazy busy this last couple of weeks for me. I finally got some paperwork accepted locally here. it was funny because at first, you get all kind of resistance when you do stuff like this until the court realizes, hey, shit, we're the ones that benefit from this the most. Plus, we get to do what we're supposed to be doing. And, if we got some bad actors, that are going to piss and moan in the audience, meaning out in the courtroom, typically sitting at the tables with the suit and the tie and trying to unlawfully attorn everybody all the time.
Right.
If we piss them off, who cares? It is what it is. So, it's just, I don't know. When I first started this, it was, I'm going to take this son of a bitch and I'm just going to give it a shot. Right. Because we know what it's supposed to look like. And here's what it looks like now. And that ain't, those things aren't, one of these things just doesn't belong here, so that's, that's kind of ended up in how I am where I am now. But now that they're starting to see the benefit of it, now they're like winging cases at me left and right and left and right. It's like, dodging cases, and it's, so it's just watching them actually study this and learn how to do it and learn that it's something that, not only benefits the person that I'm filing on behalf of, but it benefits the court at the same time. And, like John always says, what do we do about the court being in disrepute? Well, It's a matter of, look, I'm not going to stand here and plead this with you because you and I both know you're already there. And you've been there since the moment you guys decided you were going to not enforce perjury statutes. So because you're not enforcing perjury statutes, now you're guilty of subordination of it at the same time. So now you got a double whammy there.
Right.
Well, I don't know who was the brainiac that came up with the idea. We're not going to enforce perjury statutes. Not a good thing. So anyway, kind of the short of it, that's where we're at with that.
How is it that it's like somebody can, we'll even use my case right now. And I know this has happened to several people out there. Somebody makes false claims, writes up the document, and you're deprived of your fundamental right without due process of law. This process doesn't have any standing in law. I can't seem to find that process anywhere in here. It just doesn't exist. And then when I prove myself basically innocent, and you still grant some portion of it, even though it's unsubstantiated claims, here's the letter that says unsubstantiated claims, and you still perpetuate the false claims, false statements, perjury, and lack of jurisdiction when I put you on notice and make my argument that, hey, again, back to Idaho being behind the times here, it's like, what you been doing the last 17 years? You forgot to read the court reports from 2000 where it said that this document's no longer valid. It was found to be unconstitutional.
Actually, come to find out, there was nobody even making those reports. Because remember, that leg of government doesn't even exist in your state. So the people who are supposed to be doing that aren't even there. There's not even a building there. There's tumbleweeds going across the thing, right? So, it's like, well, there's land there, but there ain't nothing on it. So we ain't going to get much out of that. And, it's I don't know. It's why I said it's just absolutely bizarre to me that every one of us, myself included, and I'm like I said, I'm not, any different than anybody else out there. We went for 230 years without even completing our style and form of government. Just running along like the little sheeple we were supposed to be, doing our little thing like they were, you know, like proud little beasties. So, you know, now it's okay. Now that we know what this thing is supposed to look like, now what do we do to fix it? So it's basically, it boils down to a training issue. As screwed up as that sounds.
Oh, you mean like teach them the law type stuff?
Well, not only just teach them the law, but teach them, for example, if Congress passes an act, whatever the act is, somebody challenges it in court, and they win their challenge. So they declare the act unconstitutional, like the one you found with that particular guidance document that they were using. So without an auditor person there, somebody in loss prevention, or they call it risk management, to go through and say, hey, we don't have anybody in this position to even do this job, even though it says we're supposed to have that person right here in our form of government. It's never been done. We need to do that. And somebody needs to report that information back to us. And, you know, that's what I've been doing. I've been taking and reporting that information back to them. And it's like, you know, you can hear this squeaky wheel starting to turn, you know, and clank and clunk, and, you know, it's the missing gear for 230 years. It's that word, you know. It's like, God. You know, it's like, I was thinking about this the other night. It's kind of like a stick shift car with the clutch and pressure plate completely worn down. Let off the clutch, and that sucker ain't going anywhere. And that's basically what we've been doing for 230 years. We let off the clutch, and that sucker ain't even moving. So, you know, it's just like, damn. So you look like you're over there into a deep in thought there, brother. What are you making of this?
Oh, I'm putting out a thing here. You know, just remember, this is Kirk's Law Corner. We teach law. So
right.
I know people kind of want to come on and tell their story and all that kind of stuff. This isn't a story time. And I'll tell you the reason. Well, I mean, part of the reason why here. One, because I feel that stuff. Okay. And it affects me. Okay. I want to fix this. I want to help people. Okay. But emotionally, mentally and emotionally, it drags me down because there's nothing I can do about it. Not really. The best thing I can do, and with what we're doing right here, is we're trying to teach you what the law says as it is written, where it's at, where you can find it, and how you can use it. Make your arguments. That's up to you. You know, Chris is the one with the fancy letters and numbers and all that good stuff there. But yeah, all that stuff there behind him.
That stuff there, yeah.
You know, but you know,
going. Just kidding.
I'm not necessarily afraid of being accused of giving legal advice, because I'm not giving legal advice. I'm giving lawful advice. The law.
Well, believe it or not, there was a decision in, I think it was Kansas, of 2006, because the area of law is ever expansive. They realize that they cannot nail down what constitutes the difference between advice and legal advice. There's no, you know, plus the thing of free speech. So you're saying we can't talk about the law? No. So, you know, that shit's just not reality. You know,
we can't talk about this.
Yeah.
But like, I couldn't put you on judicial notice about this, and the Declaration of Independence isn't the law.
Right.
Yeah.
You know, and it's funny to hear them argue it. Shit like this. But, you know, guess what? That's not what the law says. The law says what it says.
That's
and,
right.
You know, it's been tested that the practice of law is a right retained by the people. So for them to go around and arbitrarily, impose these unauthorized practices on people when, wait a minute, the Supreme Court already said you can't do that.
Right.
As long as you're practicing American jurisprudence, I mean, there is a maxim of law that says we should practice our own law, right? Which is exactly what we're doing.
Suits at the common law.
That's
Where's
right.
the common law
And
courts
for them,
at the common law?
right. So for the actors in these cases, and these attorneys and these even the bad actor judges that are going out there saying, well, that's an unauthorized. Well, bullshit, I got authorization from Congress. Who are you? Right? What's your standing against me?
Yeah.
To even make such
your license to practice law at a Cracker Jack box or what? Because
yeah, did you go to law school? Did you pass?
Agency that issued you that license. I'll take it.
I just retested it for executive order.
Well,
the president,
everybody else out there, same. It's in your code. Idaho Code, Title 74, Ethics and Government here, Section 20, subsection 201. All right. The people of the state of Idaho do not, in creating the instruments of government that serve, right? Creating the instruments of government. Instruments of government. Government is a figment of the imagination. This is the instrument of our Idaho government. This is the instrument of the United States government, right? That serve them, Idaho, people of Idaho. Okay? Do not yield their sovereignty to the agencies so created. So any jerk off out there that keeps saying sovereign citizen, you need to, even in the Idaho Code, okay, it's in everybody else's code too. Sovereignty is vested in the people of the state. That is the status in society. That's what state actually means. The people, their status in society. Right. And the law is laid down through declarations. That's why you'll see in every single state constitution, the first article is the Bill of Rights. Every state constitution. And you go to Article 4, Section 1, which is full faith and credit from all. And this is the reason why the preamble says what it says is, we the people, in order to form a more perfect union, because like James Madison says, talking about the Bill of Rights and why he worded the ninth article or Ninth Amendment the way he did, that there are other rights retained by the people, and those rights shall not be denied or disparaged, was because there was an enormous amount of rights, and there is no possible way to enumerate those in all of those in a Bill of Rights.
Right.
So part of how we form a more perfect union is having each individual state's constitution with its individual bills of rights or Bill of Rights. Okay. If there's something in a Texas Bill of Rights or in a Virginia Bill of Rights or some other state's Bill of Rights that it expounds on a certain right that's not in your state constitution, that is still good to go. See Article 4, Section 1 of the United States of America.
Actually, Article 4, Section 2. It is, citizens of each state shall be entitled to all privileges and immunities of citizens in the several states, right? So, for example, if one state does institute loss prevention or some other facsimile thereof, I mean, I've just called it what I've called it because it's what I'm used to calling it. And but if somebody else does something in another state that is in some way provides a protection for the people, guess what? Everybody's entitled to that under or Section 2. So, and here's where that came from. Remember, back in the in the early part of the country, it would take months or even years for information to go from one side of the country to the other side of the country, literally.
Right.
So, there was no internet, there was no telephone. I mean, we do it in microseconds now.
Right.
And, so And the only way for them to solve the problem of, well, what about the people on the West Coast are different from the people on the East Coast? But if somebody on the West Coast thinks of something that we didn't think about on the East Coast, or vice versa, everybody should be entitled to that immunity or that privilege, right? Whatever that is. So that was basically their cure-all in the master form, right? The one that they said, okay, this is the model, right? This is the first one. And you guys are going to duplicate this to the best of your ability based on your ideology of the people who want to live within your state. So, for example, we talk about this all the time. Utah is a good example because their primary religion is Mormon. And Pennsylvania is, Pennsylvania Dutch, or, there's a lot of Amish people out there. There's, it's more of a melting pot kind of a thing. So it's more of a commonwealth. So that's what I'm saying. They're depending on the ideology of the people that live within that state, right? They wanted to, the founders wanted to make sure that everybody enjoyed all of the same freedoms and liberties and immunities from government, the tyrannical government they just declared independence from. Because remember, they went through this shit, right? And so, it's funny. People say to me all the time, that bastard should fry and blah, blah, blah. You know what? As far as I'm concerned, part of me is ready to say thank you to him, because guess what it did? It kicked everybody in the ass the right where they needed to be, to wake them up and say, hey, dumbass, get involved, do something. Don't just sit there and go, oh, woe is me and my life sucks. No, don't do that.
Yeah.
Sure. So, but didn't mean to go into a rant there, but it's to see this and see the looks on these people's faces that they literally have the deer in the headlights. They really, honestly, and truthfully don't know this stuff. And you would think that, well, should be a requirement in order to even get in the door. No, it ain't. So, and ironically enough, one of the reasons that it's not a requirement is because the forefathers also recognize the fact that as we progress through time, right, people's the way they did things, the way they did business, the way, and everything was going to change as we progressed. So they knew they had to leave that open, which is why they said in every state that the emoluments are not to be inherited, right? So if you read that, what that basically means is these practices of gerrymandering, right? Which means that they have people believing there's only two schools of thought, Democrat and Republican, right? They've been trying to ram that shit up their ass for 230 years.
We're not even supposed to have parties. We're supposed to be American. We're not.
Say that again?
We're not supposed to have parties. We're not supposed to have the Republican Party and a Democrat Party. We're supposed to be Americans, the people.
Right.
That's it. Our founders already put this down when they sat down at the round table. And we've talked about this before, the Anglo-Saxon part of things. We're not supposed to have parties. Not supposed to be a political realm of things. Not supposed to have politics as a career job.
Right.
And
it's the first
right. You're supposed to come, the representatives of people are supposed to come from the pool of we the people. Go in,
right,
perform your job, and return back to the pool of we the people. You're supposed to be one of the people first.
Right. The first sentence in the Declaration of Independence: when in the course of human events it becomes necessary for one people to dissolve the political bands which have connected them with with another, and to assume among the powers of the earth. Okay, separate yourself from the political bands. It's the first sentence in the Declaration of Independence. So
Right.
how the hell did we end up with these massive political practices of gerrymandering and all this other bullshit in the DNC and the DCCC and the ROT, the RNC and the, pick an alphabet soup. And, it's just like, God, where the hell was my head? Up my ass? And
was it dark in there? Do you need a light?
Yeah. So I don't know how else to put that, but I mean, I honestly feel just as guilty as the rest of those poor bastards. I mean,
can you hear me?
So
who do we got over there?
It's Ed.
Oh, hey, Ed.
It's me sitting here.
Ed, what's up, brother?
I got that telephone call.
Oh, you did?
South Carolina.
No shit.
Going to set up a meeting beginning of next month.
Nice.
Nice. Real nice.
That is cool.
That's the same thing we say, bro.
Is that going to be?
Let's get rid of DSS.
Yeah. So is that basically, that's in where? South Carolina, right?
Yep.
Nice.
He's going for the state position, but he is already in the political realm with them. And he wants rid of them all.
Really?
Yeah. So I'm going to hook you up. I'm going to hook you up.
I love it.
Can you post the number up there for people to call in? I know the number to join, but I don't know the number to call, and I can't
really
read it. See it.
Oh, it is a little bit. Oh, it's overlapped. Oops, let me fix that. Hold on.
Was that 308?
Sorry, I was right in the middle of something. Let me get back over here.
It's all good. We still love you no matter what.
We love you.
All right.
That's called human error.
And he's also going to put a couple other people in the office with us, Chris.
Here's my shirt for the day.
So, don't rush me. God. I want to hear about this meeting. Ed and I were talking about this on the phone a little while ago. This is a state legislator you're getting ready to meet with, right, Ed?
Yes.
Okay. Can you tell us his name?
Yeah. Josh. Hang on one second. I'll give you the full name. Putnam. Josh Putnam.
Okay.
He's going for the state position in South Carolina himself. But he's the one that just passed a law for King Care. Which is just signed into law by the governor as of today.
Nice.
I also posted it on my web. And things are happening. They just had 12 people taken down in the judicial system down there in the jails. So
where was that exactly?
There's actually 6 different locations, but 12 people that were taken down, and more to come.
Wow.
And more to come.
Holy Lord.
Good.
Monk's Corner wasn't one of them, was it?
Yes, it was.
No shit.
Yes. There's 6 of them. I don't got all 6 of them on it, but if you go in and check on the web there, you'll see them. There was a big announcement.
Oh,
FBI
Lord.
and SLED both walked in.
Uh-oh.
Yeah. It's going to fall down. Just like up here in Pennsylvania, up in the Bedford County area, there's 4 been taken down so far since that DA's been taken down.
Uh-huh.
So,
well, it was funny,
working on it.
That's like, with Elizabeth's case, it was funny when it came out, that attorney was very, very willing to sit down and say, hey, show me what you got. Before it was like they kind of gave you that old middle finger thing, screw you, what do you know, blah, blah, blah. Yep. So now that this is all starting to come down, they're starting to perk up with, maybe I better start listening here, man, because something ain't happening right, so And that's cool, you know.
Yeah, I'm working on North Carolina too.
Yeah.
I got 3 people over there that I'm reaching out to.
Nice. So this Josh guy, is he on the House side or is he on the Senate side? Do you remember? Do you know?
On the House side.
Okay, so for those that don't know, the House side is where the money is, right?
Yep.
Right.
And right now we're changing that around from Democrats to Republicans. So we're running away on them.
Well, you know, it's funny because the people, you can only bullshit them for so long, right? Democrats went in and said, hey, we're going to give you all these wonderful programs and we're going to build all this free shit, right? You ever try to use any of it? Because people that I've talked to that have, and even my limited experience with some of those agencies, it's, hey, I understand you guys are here to do. Yep, that's what we're supposed to do. Okay, I've got a thing here. And they go, oh, well, we don't do that. You have to go to court. Wait, what? That's not what you just got done saying. You said this was supposed to be a service.
One of the attorneys used to be a state representative that I had hired over there. No longer sitting. He was just removed.
Gee, I'm shocked. Because of they walked in and said we're going to do X, Y, Z, and they did A, B, C instead.
Yes.
Right.
Yes.
So this is the funny thing is it's not a matter of do we fire them? It's where does the language in law exist that gives us the right to fire them? Right.
He was one of the bar nuts.
Well, I mean, and this is the irony of this sounds a lot like one of the conversations I was having with a girl out in Utah. They're saying they were saying having this conversation about DCFS out there and the Guardian Ad Litem program, and the conversation had come out. Well, if they're not lying, why do we have to have an immunity clause at all anyway?
Right.
What the hell? Right? Yeah, we're going to get rid of that, even if we just take out the immunity clause. So you got these idiot lobbyists building all this secret language in the word salad, right?
Yep.
And, this is good unless it's the second moon of the, Juvember 97th of 2467 and a half. Right? Oh, wait, what? Was that the full moon or the half moon? I forgot,
And on the 5th leap year after Tuesday.
Yeah.
Sorry, Coke, he took over your show.
It's like, what the hell?
Yeah, I'm going to mute myself again. I just wanted to fill you in on what was going on there, Chris, and watch for North Carolina because the president endorsed this other guy that I'm talking with.
Nice.
So
awesome. That sounds excellent, Ed. I'll be listening for that.
Yes.
So
I'm going to mute myself so you guys can get on with your show.
All right, brother. Much love. We'll be talking.
Yes.
Thanks, Ed. Jody had a question here. She says, so how does that help us get our kids back or help us make legislators make changes to stop parental objections and I can say it, but pathological child abuse of pathogenic parenting, too many pay words in there. Parental alienation. Chris and I, John, other people, we've all talked about this. This stuff was a slow, methodical encroachment upon the rights. Okay.
Yep.
And we'll take you clear back to, I could take you even clear back to like 1100 AD, and even as far back as 600 AD with the Roman civil law. But mainly with that parens patriae, the king and the church there, the Roman Catholic Church.
Yep.
which is part of the reason why the separation there in 1215 with the Magna Carta, why they put the sword to King John's throat and said, look, you're going to sign this Magna Carta, the Magna Charta, the Great Charter of Liberty. You know, the reason why they do that. Religious separation. Same thing with Jamestown, Virginia. They came here in 1603, established Jamestown, Virginia for religious freedom, religious separation from, well, let's just say who it really is. It's the Crown Temple Bar. That's right out of the Pope there, underneath the Pope. So we're going to have to unravel that a little bit at a time. It is not going to happen overnight.
Yeah, I mean, they've just been doing at it, right?
Right. I can tell you some things that have worked here locally for us and in the surrounding states here is one, court watchers, large amounts of people. And I'm not talking 1 or 2 people. I'm talking 20 to 50 people get down there, get into that courtroom, sit there and watch, listen, bring a notepad, write your protests, because that's what a protest is. Write your protest and go file it with the, Department of State. That's where it really needs to be filed. If you have an OIG, Office of Inspector General, if you've got an Inspector General, file it with the Inspector General. Hey, look, I watched this case over here, case number, on such and such date. I witnessed the judge trespass the law. I witnessed the prosecutor trespass the law. I witnessed the social worker trespass the law. They lied on the stand. Blah, 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 blah. Write it all down. Number 1. Number 2, just like it's an affidavit. It's a declaration is actually what a protest really is. It's a written declaration of something that either about to happen that's unlawful or something that did happen that's unlawful. And you're bearing witness to that. That's the power of the people. So, you know, when you're the one that's standing in front of the judge trying to defend yourself and you file your complaints, they get ignored. But when they get a pile of, between 20 and 50 different people that say, hey, I witnessed this in court.
Hey, could you guys, would you do me a solid?
Something's going to be looked at there.
Right.
Could you guys?
So the power is in the people.
It
is. This is something I've been trying to get people to do for quite some time. And understanding what a protest really is, that's not out there on the corner carting a sign around.
Right.
Right out of Black's Law Dictionary. I don't know, a year ago I started informing people, educating people what a protest really is.
But it does say in the dictionary, the first definition is an active protest. The second definition is the legal definition, what you're talking about. I just wanted to chime in and say hi to our first Africa viewer. He's in college in Texas, watching right now on a brand new platform we just started streaming onto as of last night. So
hello and greetings.
Hello, Paulie. Thanks for watching on Africa TV.
Wow. Getting around the world. Well, thanks for getting us out there, Ted. Thanks for tuning in over there.
Yes, absolutely. Yeah, we look forward to, we're trying to answer as many questions as we can. I mean, what we're doing over here in the West is, the stuff that we, it's based on our law and our style of government. But if we can absolutely help in any way, I don't know much about any of the politics over there or how much, or how those forms of government work.
Well, he's watching on, it's called Africa. I don't know if it's in Africa, but he's right in Texas. And Texas. He's going to college in Texas. He's from California.
So he's over in Texas.
Yeah.
Well, Texas, I'm already in Texas. I've been there for a while. So, but, it's interesting too, to go back to what Kirk was saying about not having an Office of Inspector General. If you don't have that position, that's a problem. But you still do have one more person to go to, and that is the Lieutenant Governor. Now, the lieutenant governor, what the lieutenant governor's job is basically the same as the vice president. The lieutenant governor, in the form of if there's an event of a tie, the lieutenant governor goes into the state Congress and breaks the tie, right? So again, back to our form and style of government, by taking your complaint, even if you don't have an OIG, who would take your complaint not only to the governor, but to Congress, and it's supposed to be through the Department of Justice, but it would be, it goes directly to what we, his boss or her boss, depending on if it's a male or female or whatever, is lieutenant governor. So when you're talking about the chain of command, it's the governor, lieutenant governor, then it splits from there to the attorney general and the office of inspector general. The attorney general has one job, that's prosecute. So, one of the questions that I had is, if the attorney general's job is to prosecute, right? How is this person representing the people? Those couple thousand people standing behind us now going, dude, keep going. And so how can you be a prosecutor and representing the people at the same time? That's a conflict of interest, right? You can't be a defense attorney and a prosecutor at the same time, right? And
that attorney general over and over will sit there and say, well, no, I don't prosecute. I don't, if you file a complaint with the attorney general, well, I don't prosecute public officials. BS.
Yeah, it's word salad, right? BS. They give you a word salad. And
that's the actual purpose for the attorney general, is to prosecute public servants.
Right.
Because the people are supposed to handle their affairs at the common law court.
Right. So, it's funny when we go back to
supposed to be the public prosecutor.
Right.
Well, yes, they are supposed to be the public official prosecutor.
Right. So this is why we've got states to answer Jody's question. This is why when we go to redress our government, okay, the attorneys are trained. Well, you have to go through court first. Who said anything about going to court? My issue was the monopoly of the practice. It's got nothing to do with the practice. So you're telling me I have to go argue with the monopoly itself in order to go redress government? No. Okay, so we already know what the monopoly is going to say. It's the same shit. Same word salad they've been giving us for 230 years. Okay, well, guess what? There's more than one branch of government for a very good reason, right?
Right.
Equal protections under the law, right? So
the one branch of government didn't have too much power.
Right.
And
exactly.
The balances, the legislative branch creates a repugnant act. Okay.
If Congress isn't
sitting on the jury, okay, this is the powers of the judicial branch. We, the people sitting on the jury, are supposed to be able to look at that and go, get that crap out of here. That's the 10th Amendment. Limitations on policing powers, powers in general, the powers not delegated, okay, reserved to the people, or, to the states respectively, or to the people. What powers are reserved to the people? I mean, that's what it says. So let's discuss the part that is reserved to the people.
That would be all of them.
Well, I mean, we did delegate some powers, right? But the point I'm trying to get at is government officials say, well, we have the power to do this. We have the power to do this. Let's just discuss and itemize what powers were left to the people. Because obviously there were, because that's what it says. So what are they? Because if you're going to sit here and encourage those rights, we got a serious problem. So let's get it itemized. What powers were left to the people? And we'll discuss those first. And then we'll see what was left over and what was actually delegated to perform by Constitution, not statutory.
Right.
Not code. Code can only codify or codify the law. The law.
Right.
So when you get somebody that says, well, you just don't know the law, what are you talking about? Are we talking about the law? Are we talking about what you are trying to tell me that what is law, which is not law, because none of that is law. Can't be law. Code.
Right. That process, codification,
codifies the law. So it can't be law in and of itself.
So, right. So when you talk about the U.S. Code,
the United States
yeah.
Code, the Idaho Code, Alpha, Bravo, Charlie, Delta, Echo, Foxtrot, that's code for the alphabet. And the alphabet's code for the English language. English language would actually be the law, right?
Mm-hmm.
So to sit here and say Alpha, Bravo, Charlie, Echo, Foxtrot, that don't mean nothing to me because that ain't the law.
Right.
And it
That's
can't
phonetic. That's the phonetic alphabet. Right?
Right.
So
like FBI, CIA, blah, 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 EPA,
come on over. I'll put the coffee. Sorry.
We'll run out of coffee.
Oh, no. I have coffee in about 10 minutes. I got the coffee machine from hell, man. I can make some coffee now. Like that.
We need that in Winnebago.
Right. Oh, this is
hey, Brian. I think we're already friends there, Brian Hansen. And get a hold of me there on Facebook. He said, "Hey,
right.
CPS, should you protest before adjudicated hearing?" Yeah. Well, again, protest again is a written declaration.
Mm-hmm.
So,
well, I mean, it's funny because, when you talk about the proper way to redress our government, right?
Mm-hmm.
This is stuff now. I'm kind of old school. I was, we were taught in school, I mean, like grade school and high school, how to properly redress government on paper, right? And one of those formats was a declaration, right?
Mm-hmm.
So I wrote one, and I just kind of stapled my credentials to the front of it and said, look, in this field of fiduciary practice, you entrusted me with this license that I would do this, this, and this, but not do this, this, and this. Right? That's right.
Mm-hmm.
So when it comes to acting on behalf of a person, I have a license granted by you through the state to do that, right? That's right. Okay, guess what I'm about to do? I'm about to show you the true definition of what it means to provide for the common defense. And they went, wait, what? Yeah, it says right here in the preamble. Establish justice, ensure domestic tranquility, provide for the common defense. Okay, how are you going to do that?
As it is written.
Right. He said, how are you going to do that? And I said, see this big book right here? This big, thick son of a bitch right here? See that? I'm going to show you what kind of damage it is to actually sit down and craft a defense. Right? And it's also coincidentally going to solve this problem. So
the thing is, in reading the preamble there, where it says, we the people, in order to form a more perfect union, establish justice, that means we already established justice, ensure domestic tranquility, and provide for the common defense. That means that we do, the people do, not government.
Right. But this was basically, remember, in the context of the conversation, when I was talking about acting on behalf of another, right? I have a credential granted to me by Congress, right? It's the license number. It's on the cover page that says during transactions, the largest transaction people will ever make in their entire life, you, Congress, granted me the ability to act based on this fiduciary on behalf of another to make sure that those deals go down exactly the way you write that process, right? and to liaise between the banker, the purchaser, the seller, the brokers, the other agents, the home inspectors, yada, yada, yada. I mean, the list is like
repo man, the bounty hunter.
Repo man, he says.
Right.
But
all in the same book.
Right. So, and I said, okay, you guys came up with a set of criteria. You call it the Code of Ethics, right? That's right. Okay. Based on that code of ethical practice, if I were going to represent somebody who was into a contract, and consequently, I do have a client that is in the middle of real estate transaction, whether the court wants to admit it or not. And part of that transaction is a standing order that an action is supposed to happen, and it hasn't happened yet. And I said, well, as a fiduciary, my fiduciary duty is to that contract. That contract, it just so happens to be a judge's standing order based on a memorandum of understanding. Yep. Well, the other actors don't want to enforce that. They want to try to usurp it through a subversion of the process. And I said, no. And the appeals court said, no, you can't do that. So now we still have, and the more we prove this to be true and correct, our version of it anyway, the more the swamp monster gets pissed and retaliates, right? So, it's just hilarious that, I can walk into Congress and say, well, look, yes, based on the book of defenses and the contracts and this is what should be done, right? Yep. This is what should be done, right? Yep. And, I'm going down through these whole things step by step, right here, right? Yep. Right here, right here. Yep. So then where's the rest of this crap coming from? I said, well, number one, you're going to have to ask the actors over on the other side of the table because they're trying to claim good faith. And I can tell you right now, as many times as I've read this big monstrosity, good faith ain't in here, right? I've read that son of a bitch cover to cover more than once. Good faith
about that?
In this book, right?
How about that? Go back to that ethics part there, back to 1770.
That's in this book.
Well, June 12, 1776, the Virginia Declaration of Rights, Section 4, that no man or set of men is entitled to exclusive or separate emoluments
right,
or privileges from the community, but in consideration for public services, which, not being descendable neither off the offices of magistrate, legislator, or judge, be hereditary. That's ethics in government. This is part of our ideology, theoretical foundation of government.
Right. So when it comes to, well,
you having a problem over there?
How do we, so the word emoluments does appear in law. It does appear in American jurisprudence.
Sure does.
So why has it never been argued? Right? And basically, here's we're going to go through, we're going to start reporting on all of these repugnant acts. Now, Kirk talks about Magna Carta. The right to a trial by jury was established back to the Magna Carta, and even actually a little bit before that. But
1166 with the Aziz is the original origin of the right to a trial by jury.
Right. So who the hell is the Congress that wrote and took that right away and usurped the law? That was
right here.
Huh?
It's right here. Remember, we've been over this before. I've been through the annotated Constitution under the right to a speedy trial. And it comes from Chapter 40 of the Magna Carta. This is called succession of law. And this is where I use the annotated Constitution as evidence to support my claim that rights carry forward and they cannot be diminished. Okay, that's called succession of succession of law. Rights are the law. Okay, bills of rights is the law, the common law. That's American jurisprudence. Volume 16, Constitutional Law, Section 100. Bills of rights are merely declaratory of the common law. But right here, they go through and they say, okay, well, the right to a speedy trial is from number 40 in the Magna Carta. And then it goes right here to the Virginia Declaration of Rights, June 12, 1776, then into the Sixth Amendment. Okay, but when it comes to the right to a trial by a jury, they seem to forget like the rest of the sentence where they found the right to a speedy trial, which is right here. That is section number 8 of the Virginia Declaration of Rights, June 12, 1776. That in all capital or criminal prosecutions, a man has a right to demand, right? Demand, okay? The cause and nature of his accusation. To be confronted with the accusers, this is under demand, okay? Accusers and witnesses. To call for evidence in his favor. So when they do like a motion in limine, that's unlawful. Okay, denial of exculpatory evidence. That's right here in the law. Your rights. Okay.
Does it say 180 days?
And to a speedy trial by an impartial jury of 12 men of his vicinage. Now listen carefully. Without whose unanimous consent he cannot be found guilty. Nor can he be compelled to give evidence against himself. Okay, that no man be deprived of his liberty except by the law of the land, that is due process of law, or the judgment of his peers. That law of the land is this. Okay, this is the law of the land, not code. So this one's the supreme due process of law, or the supreme law of the land. This one is the law of the land of the state, and this one is the law. This is the process of bringing things into being. And this is where we use that legal maxim of law, core concept of law. A repugnant act cannot be brought into being. Because if it's repugnant to this, it has no standing in law. It's foreign to our form of government and repugnant to the law. And in some cases, a declared act of tyranny in the Declaration of Independence. And when we say repugnant to the law, law is that which is laid down, ordained, and established. The first part of creating a nation is you have to lay down the law through declarations.
Right.
So this is one of those declarations that lay down the ideology, our common law, the law of nature, naturally, self-evident, as it says in the Declaration of Independence. This stuff is supposed to be self-evident. We're supposed to
have a pocket version of you, Kirk.
Say that again, brother.
What's that, Ed?
I said, do we have a pocket version of Kirk? I need him in my pocket.
Well, if he's a little
actually, we do.
Yeah, I seen that paper. Like, I want his voice. He takes them right out, and he don't even think twice. He just pops them.
Right?
Yeah.
I've been at it for 23
Well, I mean, it's funny, we talk about where this stuff comes from, okay? So we know in our succession of law, what we're talking about is we're not fighting over the law, okay? We're fighting over the process of law, right? The practice of law. So that's why you say it doesn't matter what the law says if they're not practicing it the way it's written and intended.
Right.
Well, okay, genius. Guess what? I can definitively show that too. So
the key here is we are the bringers of the law. We are the law sayers. That's the lawyer. Okay. Yep. We're dealing with attorneys, not law sayers. They don't speak the law.
Right.
So this is the reason why we need to educate ourselves on where in law, as it is written, what it says, so that we can effectively claim those rights. Okay.
Yep.
When we effectively speak the law as it is written, that umpire up there calling balls and strikes, judicial notice, Your Honor, And I happen to own this book. I own the 21 volume set. Okay, so I can put them on judicial notice, but I can show you in the annotated Constitution where it says this same exact stuff. The source for the Virginia Declaration of Rights is Thorpe the Seventh, pages 3,812, 3,000 through 3,814. Okay, this is documented in our history of law.
Mm-hmm.
This is no joke. This is the real deal. So we have to be the law sayer. We're the lawyers. And that's the difference between a lawyer, one who speaks the law, one who is knowledgeable on the law, and an attorney. Because they're, the root of attorney is a torrent.
Right.
And the definition of a torrent is to take your property and give it to somebody else.
Right.
In current 2018, with the current events going on with our administration and government, that amounts to human trafficking, Section B. When we talk about human trafficking, most of the time the people think about the sexual side of things. But there is two sections. You got A and B of human trafficking. And human trafficking on the Section B part is the debt slave, the money side. Yep. So they're, aside from the birth certificate and the social security number and all that stuff, the family law people out there or criminal law people out there, you go to court and you're fined. You got to pay court fees. You got to pay this. You got to go to an alcohol class. You got to go to this drug class. You got to go to drug court. You got to go do this. You got to go do that. You're a pretrial detainee. And, this is part of my temporary new job is I'm doing drug screens. So, I'm pretrial. What the hell's a pretrial?
Right.
We haven't gone to trial yet. You haven't been found. You're still innocent.
That's
but
where you drink the Budweiser.
Drug screen. That's deprivation of your right to life, liberty, and pursuit of happiness without a trial. That's a bill of attainder. That's policy. That's a guidance document. That's unlawful. Yep. That is repugnant to our form of government, repugnant to the law, or foreign to our form of government, repugnant to the law, and right back to the declared act of tyranny. The legislature legislating for us in all cases whatsoever.
Right. Nope.
Get the hell out of here. You don't belong here, and neither does that crap.
Right. So basically, this goes back to what Benjamin Franklin said, right? Anyone who is willing to give up a little liberty for a little security will deserve neither and will lose both, right? Guess where the hell we are? We are right at the cusp of that point right there, because you've got a bunch of, classification of people out there. I'm not even going to get into the politics of it because it drives it. Talk about make my head explode. That they have this mentality that, they're just entitled to everything. Excuse me, what?
Say hello to John.
I was just going to say, welcome John Gentry to the show tonight. He finally made it. And of course, we kind of messed him all up with a temporary job. So,
right.
Welcome to the show, John. How are you,
brother? How are you guys doing tonight?
Not too bad, brother. What you up to?
We're ramping up, getting ready with our lawsuit, United States Supreme Court, People of the United States versus the 50 United States. Picked up 1,000 new members today that joined our group. I'm going to post a link here for our viewers that are on there. This is a closed group, but we'll pretty much let anybody in. And what we're doing is we're suing our state governments, demanding reform. And so click on that link and join the group. We're going to be taking original jurisdiction action in the United States Supreme Court. We've already talked to the Supreme Court. They'll docket the case. People are excited about this. People want a way to do this. Everybody's tried calling the media. They won't tell the story. People have tried calling their legislators. I've proven the legislators are in league by enacting these laws that protect corruption. The legislators aren't going to help us. We try to defend our rights in U.S. District Court, and we appeal to the circuit courts, and they won't do anything either. So we're going straight to the top, and we're going to see if these guys, our current 9 justices, are going to uphold the Constitution or whether they've been corrupted as well.
Right.
So you guys click on that link, join that group, the people of the United States versus the 50 United States. And, we got like 1,000 more people joined up today. We want to go into the Supreme Court with 500,000 people saying, you guys need to unscrew this mess. We need to get rid of these emoluments violations. We need to get rid of these laws that incentivize the government to violate our rights and to take away our children. We need to have a means to address grievances against the state and enforce our right of due process. And we're going to take these bastards to task. I tell you, people are excited about this. We're putting our heads together. The team on here, Chris and Kirk, we're all working on this. So
is it me, John, or is that pile of paper behind you to your side there? Is that sucker getting bigger and taller every time you come on the show?
It actually moves. It actually moves around.
I'm like, okay, we're going to be seeing a pile of paper on the show next week, and we'll see just the top of John's head kind of bouncing behind the paper wall. So.
It actually went down. I just filed 40 pounds in the United States Supreme Court. Hopefully everything will be in compliance. But that case is for me to learn the system, learn the process, learn their rules, figure out what hoops they're going to make me jump through, and whatever hoops they throw in front of me, man, I figure them out. So I just sent them 40 pounds Monday. It should be docketed. I'm hoping they're going to docket this time. Hopefully in the next couple of days. So the stacks move around, Chris.
Hey, John.
I see that.
John, you there?
Yeah.
Can you hear me? John.
Can you hear me?
Yeah, I can hear you. What do you think about sending that to some of our political people that Trump's standing in line with? A copy of your write-up on that 50 states.
Oh, he's definitely going to be copied on it.
I got a couple political people I'm working around.
Yeah, I've been keeping them aware. You've been keeping Congress aware of what's going on, and we're gonna keep letting Congress know and the president know and the Supreme Court know.
Yeah. Okay.
We're gonna be heard. Damn it.
Yeah. I think we're starting to do it in South Carolina and North Carolina. I think
it's happening.
Stepped on.
You got to get people organized, come together, speak up, speak out. I mean, I've been down to my
be afraid.
Working with a few different Idaho representatives. Yeah.
Well, this is the greatest thing, glad you joined us, John, because I was talking about this earlier in the show. You had raised the question about the court being in disrepute. And it's like, well, that's not a question. We're already there. The question, are you? The question is, how do we unscrew it? So, kind of the long and the short of it is I'm kind of like rephrasing your question a little bit in this new series, in the updated series of amicus reports I'm doing for people. Uh-huh. And it's like, well, look, you know it, whether you know it or not. Here it is what it is. And I'm not here to beat you up over it, right? I'm here to just point out the obviousness of it and say, based on my recommendations of the credentials granted me by Congress, which I will be reporting back to, I'd like your input on this theory to bring the court out of disrepute. Is this something you would support? Right? And here's how it works. Here's the client. Here's what happened. This was the first part where the wheels came off the wagon, right here. This was the original bad action, right? Can we agree on that? All right, good. And the reason that we know it's a bad action is because the rules say that this document, say an affidavit of truth, for example, is supposed to be signed under penalty of perjury and stamped, notarized, blah, blah, blah. And it's got all these criteria. And we can go down through damn near every one of them and find a deficiency of some form, whether it's be deficiency in the preparation of the document itself, or whether it be something in the language of the document that we can, kind of like give it the old sniff test and go, I smell bullshit, right? And here's the proof of why I smell bullshit. So because of that, and we know that, and we can definitively show that, and unfortunate circumstances is it makes you look bad, Judge. The only real recommendation that I can give you based on the work that I've already done is here's what the federal court says to do, which is go back to that document right there, that thing, okay? And you literally wipe the damn table clean, right? It's void from its inception. And that case is Schumacher versus Schumacher, right? So we can take and go back to that event, right? And say, because that event was false, we can use the Schumacher case. We can actually throw in some other stuff, like the falsus in uno doctrine, right? False in one thing, false in everything. So everything else after it is also false. And of course, like I said, I put these reports together, 1,000 pages-ish, and the court's looking at it, the attorneys are looking at it, the courts are looking at it, and they're going, well, duh. And I'm going, yeah, duh. And they're going, okay, so now what do we do? Well, you do this. Okay.
Follow the law.
Yeah, because here's what the law says. And I'm not talking about guidance documents, statutes, codes, rules, regulations. That's stuff for you. We'll talk about that later. Right now, it's the law, right? Yeah, and the practice. Huh?
I said to the Sixth Circuit, I come as a friend of the court. I have no desire to bring the judiciary into disrepute. You guys do that well enough on your own.
Right? You didn't need my help, stupid.
Yeah, bad actors aren't the court. The court are the persons who've been entrusted to uphold the law and to render decision based upon rules of procedure and upon the law. And the bad actors that don't do that, not the court, they're just bad actors. And I said to them, this case should have been put away a long time ago by addressing the conduct of the bad actors. And instead, the process has been compromised at every level, trying to protect these bad guys, and so where's it going to stop? Are we going to put the Supreme Court in a position where they become bad actors? God, I hope not.
Right.
I hope that somebody's going to enforce the Constitution at some point. And, I'm going to take it all away. And I trust in my government, and, I hope that they do the right thing.
Well,
and
we keep talking about enforce the Constitution and stuff. It's enforce the law, because the Constitution really isn't the law. The Constitution's it's actually due process of the law to bring things into being. Like
so, we talk about
like the governor,
process, right?
Right. The process of bringing the president into being, the process of bringing the governor into being, the vice president, secretary of state. All of those positions in government is what the Constitution actually does, is it brings those positions into being.
Right.
In writing.
Well,
because
and
government doesn't exist. It's a figment of the imagination. So, and the law is the law as it is written, and those people are supposed to uphold and support the law.
Right.
That's what.
So when we talk about the judicial process, the way it's written, okay, we have this. That's a good point to figure out, where does the law and the process stop and the rules of the court begin, right? Now, for the attorneys to answer that question, they say, well, you have to be attorned first. Well, where's that in the law? That's not in the law. You made that up, right? And that's exactly the truth. They've made that up. They have created this fictitious belief, and they're calling it a license. A bar card is not a license. It's not registered with the state. I know, I've looked for in Florida. They're not registered with the state. So tough. They're not licenses. Too bad, so sad. It ain't a license. Kiss my butt. So that said, you've made up this fictitious process, okay? And you've made these rules or guidance documents, same, and you've taken this process and blown it way out of proportion, right? Why is there 700 and some odd number pages of civil procedure, right? That's not even criminal. That's just civil procedure in my state alone. And you're going to tell me that the average person, based on what the intended purpose of this says, that doesn't look like no 700 some odd pages. Sorry about your luck. So how the hell did you overwrite this with 700 and some odd pages? And now you have now you're basically also laying the claim that I can't redress my government without you. No, wrong again. That's not what the rules of Congress say, because the rules of Congress say citizen petition, U.S. Code Title 15, Chapter 53, Subchapter I, Subsection 2620A. Citizen petitions. Right there. You want to petition your government, Congress, that's it, right there. So you write up your document and you can petition it to Congress. It doesn't have to be a family law case. It could be, hey, guess what? This road my road's got a pothole in it, and it's been there for 17 years, and the sons of bitches won't ever fix it. I want to redress my government. How do I do that? Yeah. Okay, well, in the state of Florida, there's a good couple of rules right there, right? You can write your senators or your congressmen, if you can't get any kind of relief and remedy from the street road department, you go straight to Congress. You don't need a court for that.
Yeah.
So
I'm going to hit a couple of comments here real quick, Chris.
Yeah.
You have something, Kirk? Yeah.
Yeah. I was gonna bring Crystal on. She's called in like 3 times now. So let's bring her on. Hold those questions.
Let me hit this real quick. Cheryl made the comment that I'm working harder than Chris because I got bigger stacks of paper. Chris has got a separate room where he keeps all of his work, and he's probably more buried than I am. And all of us are researching the state constitutions across this country and the state statutes across this country identifying unconstitutional laws. We are working our ass off, not just for ourselves. I mean, I'm not fighting my case. I'm fighting everybody's case, and I hope you guys will join me. Let me post this again. This is a link where we're putting everybody together to go out and bring an original jurisdiction case in the United States Supreme Court. So, join that group and become a co-plaintiff and demand reform of the states. But, man, we're all working our butts off here for sure.
This is actually a corner in a spare bedroom that I set this up just so I could do the show. So, yes. It would look, somewhat professional and intelligent and
not messy like
that. My office is 10 times worse than John's. It's just like, it looks like somebody cut trees down and just it's stacks of paper and stacks of paper. It's like, oh Lord. That was kind of like my joke. I think John's ready to have a race with the stacks of paper. You want me to go out into the main office out there because yeah, that's brutal, man. I found out I'm actually in 19 states. I got that news this past week.
Yeah. And Alan made a comment that he was working through some of the documents today. And I'll tell you, this case that we're working on in the Supreme Court, everybody that has looked at it, that has the smallest inclination to understand the law is just like, holy crap, this is the answer. This is how we're going to change this thing. Nothing else has worked. This has never been tried. So, I know Chris and Kirk and so many people are excited about it. So, Alan, thank you for taking a look. And I encourage everybody else to take a look at what we're going to be filing against all 50 states.
Right.
Okay, let's bring Crystal on here and see what she's got going on.
Thanks.
Well, hello, guys. It's been a while since I talked to y'all.
Right.
What's going on, Crystal? Actually, you talked to me today. Don't you be lying.
Well, I know. That's because that's what happens when I'm on disability and now I can't work.
Well, that's, quit having surgery and you'll be all right.
Right? That would be the whole entire goal, right? We're trying to figure that out, how to stay out of the hospital and how to stay out of the doctor's office. And courts. So, okay, explain to me a little bit, and I don't know, I know you guys have probably beat this issue to death on a writ of mandamus.
Well, we petitioned for a writ of mandamus, remember, in your federal court. Remember what
right. Right. Well, I know that. And so now I'm talking about making the appeals court, making the lower court uphold an appeals court ruling.
And that's up to the judges to do that, isn't it?
Well, that's what I'm wondering. Do you file a writ of mandamus in order to say, hey, appeals court, dude, you need to tell the lower court to do this?
Well, they actually did. That's called the
remuter.
Yeah, when they filed the remuter did go with orders, remember?
Mm-hmm. And so, but how do you, so you have the lower court saying, I don't give a shit with what the appeals court says. I do what I want.
And there's your answer, right? It literally had to come to the head to where the admiralty jurisdiction, the court with the gold fringe on the flag, had to look at the court of law, the one without the gold fringe on the flag, and give him the finger, right?
Yeah.
So, in essence, that's exactly what happened in your case.
Right. But how do you make a judge? How do you get an appeals court judge to say, hey, dude, lower court dude, you can't do this?
It's called you're under arrest for a violation of a lawful order. You're in contempt.
Right. But don't you file a mandamus to bring it to the attention of the court?
You're the free state.
You're carrying a lawful order in the appeals court. That's a lawful order. That's an irreparable offense.
Right.
But don't I have to bring something to the attention of the appeals court for them to do it?
You are carrying the lawful order. They already laid the appeals court. They already laid down their ruling.
Right.
Yep.
You're holding the lawful order.
Right. Remember, this is what pissed them off in your case, Crystal. We walked back into the lower court with the orders from the appeals court in hand, right?
Right. Yep.
And they're still trying to go usurp the law, usurp the appeals court and the higher court through subversion of their fictitious process. So we grabbed that judge and bad actors in your case and ripped them off the bench and threw them into the appeals court. And the appeals court said, well, yeah, no, under Rule 4, right?
You can't do this.
Under Rule 4, you can't do this without da-da-da-da-da, right?
Right.
So the answer is, it's not a matter of how do you get them to, how do you get them to do it? It's who do you go to for enforcement of that actual lawful order?
Right.
From the appeals court, right?
Well, would that be a writ of mandamus?
Well, again, actually, you don't need a writ of mandamus, like Kirk says. You have the order, right? You should be able to just walk into enforcement and say, hey,
lawful order.
Yeah, I have a lawful order here, right?
Mm-hmm.
From a higher court. right? So if the lower court does not meet the standard, at least of this order, then it's void from its inception.
Well, right, and I understand that, but it's how to get my kids back when the appeals court says, no, you can't change what has already been written because it was done under mediation.
But the ruling that we got from the appeals court clearly said,
right, they don't have jurisdiction to amend it.
Modify the actual divorce decree, right? Because that was the question they cannot amend or modify the divorce decree without proof of abuse or neglect.
Right.
And again, we walked into the appeals court, same thing, with the proof that there was none. So that's why I said, this is, what we're finding out now. What is first, the cause or the effect? Because we can bring the effect before the cause, the way we did your case. That's why I said that's the calculus, right? So, because we practiced calculus in your case, literally doing what we did, this is what pissed them off.
Right. Yes, exactly. So so I'm a little confused. So I need to put something into the court, to the appeals court, that says, hey, the lower court isn't listening to you.
Yeah. Basically, we need to figure out a way to tell them, and I can't, like I said, I'm working on it. I haven't gotten through it yet. But we literally got to figure out a way to walk into the appeals court and say, appeals court, remember that remuter you filed with the order? Yep. They looked at you and went, flipped you the bird, right?
Yep.
And what are you going to do about that?
Well, that's what I'm saying. Wouldn't that be a writ of mandamus in order to force them to do that?
No, John, jump in here. What do you think?
You already have an order from the higher court telling them what to do. You don't need a writ of mandamus.
Okay.
You already have the order in hand.
Yes, I do.
You're under arrest. Here's the lawful order. You are in contempt of the appellate court. 3 judges have told you to do your job this way. Here it is in writing.
Okay. Well, and I understand all that, but how is it that I get the court to understand that you can't do this?
You are under arrest for contempt of court.
The judges.
Repeat that.
I would put that in a petition for contempt.
Yeah.
That's how I would do it. And just
to the appeals court.
Write an affidavit.
You could do it in whatever court, but I would do it in the court that you're in and just petition for contempt and say, here's what the order says. They're in contempt of the order.
Yep.
Okay.
Submit the order from the appellate court. That's basically you're telling the judge he's under arrest.
And then if they won't,
they're not a judge, they're administrators.
Yeah, and if they won't enforce the petition for contempt, then go for a petition of mandamus to a higher court.
Okay. So basically, Chris, I took your order that you wrote, I added in what the appeals court said. So now I'm going to call it, instead of a writ of mandamus, I'm going to say a petition of contempt on the judge.
Yes, take it to the clerk of courts.
Right.
Take it to the clerk of courts. Make sure it's
in the appeals court.
You also need to take that to the lieutenant governor, because remember, your state does not have an inspector general, right?
Right, or a state department or whatever they're called.
Right. We've been running into this problem with your state because of that constitutional deficiency, right?
Okay.
And remember, we knew this was going to be a problem. We talked about this in the beginning. We didn't know what it was at the time, but now that we know what's missing, we're going to have to go lobby this in Congress, and I'm going to help you do it as much as I can.
Okay, I got it. Okay, so petition of contempt. So basically what I say is, hey, the appeals court ordered that you can't amend and modify, and the judge, whatever her name is, not going to say, said, I don't give a shit. Huh?
She's a hearing officer. She's not a judge.
Well, okay, so then say, okay, the blank in my court said, F you, I don't have to uphold any other court's decisions.
She said it on the record, Crystal. She admitted.
Yeah, I know. Yeah.
She literally
Anything
shot
said
herself.
in open court and on the record is an automatic arrestable offense. Just saying.
Yep. Okay, so I need to amend it from a writ of mandamus to a petition of contempt and file it with the appeals court tomorrow.
Right. Under Title 18,
right.
Section 2.
Subsection 242.
Right?
Subsection what?
242.
342 or 242?
242.
Because that's collusion, right?
No, that's deprivation of rights. 42,
okay.
1985 and 1986 is the
collusion.
Conspiracy to collude, blah, blah, blah.
Okay.
You have definitive proof because by admission, she testified against herself on the record.
Yep.
Right?
Yep.
That is a deprivation of rights under Title 18, Section 242. It is what it is.
Yep.
Okay.
It's been admitted in court on the record.
That.
And I want to jump in on that 1986, which is conspiracy to deprive rights. And when that was first enacted, they didn't have anything about the equal protection in that clause. And then Congress is like, oh shit, we gave everybody too big of a chance to go after these bad actors. And so we need to close that loop a little bit. And so they added equal protection language into it. And now you have to show that you were deprived rights through conspiracy and that you're a member of a protected group or that you were discriminated against. more discriminated against than a protected group. You know, they discriminated against me because I'm black or I'm gay or, you know, whatever, you know, hiring or whatever. So 1986 became very difficult when they added that language in there.
Well, and again, because she's a woman, under women, she is
a minority.
Under VAWA. I don't know, is VAWA even still a thing? I keep hearing conflicting language. Violence against women, is that still a thing or is that debunked?
Yes.
It's still there.
All right. So under VAWA, she's a protected class, right?
Mm-hmm.
Yep.
So there's your protected class. There's the conspiracy. There's the admission, which, believe it or not, is a maxim of law, right? There is no better, you know, how the hell does that go? Something about there is no better witness than a confessing defendant.
Yep.
It's a maxim of law, believe it or not.
Okay. So exactly what is a remuterer, whatever you say, however you call it? What exactly is that?
That's when the higher court takes the case, throws it back at the lower court with instructions to that hearing officer or lower court judge or whatever, and says, do this, right?
Okay.
And that's not what happened.
Right.
Crystal, did you take that into the clerk of courts and file it? Can you hear me?
The contempt one?
Yes.
No, not yet.
Okay. Well, the paperwork that you got back from the higher court, my suggestion, these guys will tell me if I'm wrong, but my opinion is to take it in and file it with the clerk of courts in that same court proceeding area. And you'll find out that that judge will get it, and then they'll remand whatever they start.
Okay, so my remuter says, it says the above entitled was submitted to the court for decision, and the decision has been issued. That's the whole entire remuter says.
Right. So you're going to take that remuter with the decision that we got from the appeals court, the first one we got, right?
Right. Right.
You're also going to take the decisions from the federal court. Remember, what was that? 5 orders that we got from them? You're going to take all of the orders that we got from all the courts in your case, and you're going to bundle them up. You're going to what do you think? Attach them to an affidavit or a petition, John? Which better do you think?
I think a petition of contempt.
Should we do it as a petition or should we do it as a memorandum or an affidavit? What do you think, John?
I had a hard time hearing that.
Do you think we ought to take all those orders we got from the court, bundle them up, under a petition, a memorandum, or an affidavit? Which would you do?
Well, I'd do the petition and then a memorandum of law supporting a petition for contempt, and attach all of the evidence to the memorandum of law and say,
okay,
here's what the law says about, enforcement of orders and why those orders were granted in the first place. And here's the evidence that they're in violation of that. So the petition for contempt would be just a short, here's what's going on. I would ask the court to hold this person in contempt, and then back that up with a memorandum of law with evidence attached to it as exhibits. And you've got a really adverse court when you go into the clerk's office, have each piece of evidence or each addendum file stamped as well.
Yep.
And that's a way to hold them accountable for getting things properly reflected in the record.
Yep.
They'll lose that shit.
Oh, I know.
There wasn't an attachment to this. They didn't file it. Well, now I got to file a stamped copy. Yeah, I didn't.
Okay. Okay. Did you get all that, Chris? So you can tell me tomorrow.
Yeah, I did.
and I would spin it if there's any way you can.
Sorry.
All right.
This is what happens when your brain is still on surgery mode, and I'm freaking tired of being sick, and I'm tired of not walking.
Right.
And if there's any way you can spin it, you have such a low probability of success if you're saying a judge is in contempt. And if there's a way to spin it that the parties or opposing counsel is in contempt, I would spin it that way. Because it just makes it so much harder when you're saying a judge is in contempt, because as it stands right now, apparently judges are above the law.
Right.
Well, actually, what I found out something really cool is Utah actually has a law, and I'm waiting for the dude to give me the information that says that in Utah you can file because of some rogue judge that was back in the 1800s. That they drafted a law in the 1800s that says you can do a civil complaint against a judge.
Well,
it's one of the few states that you can actually sue a judge.
I've already proven in district court and in the Sixth Circuit that they will not enforce the Constitution. They will not enforce the U.S.
Oh yeah, well we know that.
Against a judge, they just won't. The only possibility I think of that happening is in the United States Supreme Court, because the district courts are very obviously in league with the state governments.
Oh yeah.
I mean, the evidence is there. You can go to any district court docket and you can see they dismiss every case under false application of sovereign immunity, judicial immunity, and then they misconstrue Rooker-Feldman and do that too.
Right.
So I, my position now is if you've got a complaint against the judge, you do a extraordinary writ in the nature of mandamus to the United States Supreme Court. You go straight to the top and you say district court, circuit court won't enforce the Constitution. Here's a couple of cases out of the district court, circuit court, proving that the circuit court and district court won't enforce the Constitution. And so I think it's an exceptional matter of public importance that should be heard under Supreme Court Rule 20, and just go to them. If you go to the district court, it costs $400 to file in district court. And then you're going to get stuck in there for a year while you go back and forth over a bunch of crap, and you show them the law and they ignore the law. And then you pay another $500 to appeal to the circuit court. And you get more of the same crap where they won't enforce the Constitution. They won't enforce the USC against bad actor state officials. So why waste all of that time going to the district court and circuit courts when you go straight to the Supreme Court and pay $300 and get the same thing? And we all started doing that. There's like something like 246,000 pro se cases filed in the district courts. More than half of those go to appeal. Now imagine if that 246,000 instead went to the Supreme Court. The Supreme Court would be like, what y'all got going on out there? Because we're getting a whole lot of crap right now.
Something I want people to take a look at. In that treason on arrest and false imprisonment, okay? Right
Don't
in
forget
there,
treatment on impeachment.
3 documents that you need. Okay, and it gives you the memorandum of law and points of authority. Okay, it's all there. All you got to do is take the information from your case and apply it into those 3 documents: the summons, the complaint, and the itemized list of the crimes. It's all there.
Right. Here's the other thing we can do in your case, Crystal. While you're sick and down, right? I have already emailed you the preliminary version of your judicial report, your follow-up report. Right. That is going to go directly to Utah Congress. You have Congress's ear. You can have a judge impeached from the House of Representatives because you have the appeals court orders that the lower court, that judge is refusing to follow, right? So that gives the green light to Congress to say, yes, we are going to impeach this judge, this hearing officer, whoever the hell she is, and rip her ass off of that bench. And we're going to make whoever replaces her in the inherited emolument, that chair, we're going to make sure that whoever we replace her with will follow the higher court's orders. That's conditional.
Right. Or let's just eliminate that position. We're not supposed to be in front of administrators.
Or, right, that also gives, at that point in time, that gives Congress to say, well, wait a minute. This woman basically flipped us the bird anyway, right? Said, well, we don't follow the law. We follow the rules of the court. Which is basically stating we're following guidance documents. Fuck you, Congress. Those are not law. At that point in time, Congress can go in there and axe the no-fault divorce under admiralty jurisdiction, right? And say, hey, we like this brokerage firm idea a lot better because these guys are smarter than these guys, and these guys will comply with what we tell them to do.
Right. And see, and that is what has been nice in the last couple of weeks, is getting the ear of our senators, or my local senators and legislatures, and getting them on board with, the rogue GALs and the rogue attorney, the rogue, courts. I've got the ear of these legislatures that are all out there because I've had the time in the last couple of weeks from knee surgery to be able to send them text messages or email. And I'm sorry to sound like Jody, but I'm getting responses. I'm getting their personal phone numbers, and they're saying, hey, call me and let's talk.
Right. I got a better idea. I can give you something that's based off of more stuff that Congress wrote, right? That fiduciary practice is something Congress wrote. And we've been doing it for a very long time, and we don't even have to bother with hearing officers. We don't even have to pay courts. We don't have to pay judges. We don't have to pay attorneys. We don't have to pay those people. These people in these brokerage firms can do this lightning fast and be done with it, right? So we need to give them something, an example of this to duplicate, so they can say, yes, this is what we want to do because these bastards ain't doing it anyway, right? They keep giving us the bird. We say, hey, you're going to do this, this, and this. And the only thing we get is pushback from the Judicial Committee saying, well, we don't like the word shall.
Yeah, they do. Yeah, exactly. Yeah, they don't like shall, and they don't say you have to or whatever.
Right.
They don't.
We can giveth, we can taketh away, right? We tried it didn't work, we can take it away. And we can make this process very short, very sweet, very manageable, and reports directly to Congress. And we can go right around the courtroom. We don't have to mess with courts, because guess what? When it comes to questions of what are parental rights? Well, Mayor versus Nebraska says that even people that are incarcerated have a liberty interest in children.
Yep.
So it doesn't even matter if you're incarcerated. You still have liberty interest in your children. So, they can whine and cry and scream and torn and piss and moan and blah, 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 all they want. We tried it. It didn't work. You're back to your same old parliamentary practices under admiralty jurisdiction that we declared independence from, right? That's where the declaration comes in.
So if I'm writing this, petition of contempt, I'm going to say the appellant respondent comes before this Utah Court of Appeals on this petition of contempt under USC 18242. The parties signed a memorandum of understanding making an agreement. On August 1st, 2017, the Utah Court of Appeals upheld the divorce decree and memorandum of understanding. On October 10th, 2017, sent a remuter to the Second District Court that says this lacks subject matter, this lacks jurisdiction to amend or modify a judgment after 30 days.
Correct.
On January, the Second District Court stated, I don't uphold orders from another court.
Right. And why is that a problem? Remember?
Right.
Okay. I'm going to answer the question because it's relative, and it is it's not just ineffective assistance of counsel. There's another one that's in the follow-up reporting. It's called sanctions imposed by courts on attorneys who abuse the judicial process.
Right.
It's part of the follow-up reports, Crystal. I have got to get your report done. And yes, it's already mammoth. It's already almost 3,000 pages. I need that sucker done. I need to get that case done. Congress indeed wants it. So we got to get on it. We got to get that done. And while you're down is the perfect time to do it. So
yeah, I know, but I've found other things to do since I've been down. Okay, so I think I found one. I just have never seen a writ of petition of contempt. I guess it would be the same as an order to show cause as to why the lower court isn't upholding the order from the higher. It's not even from the higher court. It's just from another. It would be literally like one judge, like a judge saying, "Okay, I'm sentencing you to death." And the next judge coming along saying, hey, that judge really isn't that cool. And I'm going to give you a life sentence instead of death.
Wrong.
Right.
We have to show Congress that the usage of admiralty jurisdiction does not conform with constitutional mandates. That's the disconnect. You've got a court of equity under admiralty jurisdiction, the gold fringe around the flag, right?
Right.
And you're going into a court of law with no gold fringe around the flag, that's what I'm saying. It's oil and water, right? They don't mix. That's why courts of law do not want to hear cases out of courts based on admiralty jurisdiction, because they know it's repugnant to our form of government. They know it brings the courts of law into disrepute. Under a monopoly, they can't even say it. We have to say it. That's our job. Establish justice. Says so right here in the preamble. Right? Establish justice right there.
Ensure domestic tranquility.
Yeah. If we don't do it and do it the right way, it's never going to get done.
Right.
So,
and mine's pretty much a test case because I'm willing to push it as far as I can.
Hey, we're all doing it, Crystal. Every one of us. You, me, Nate, John, Kirk, all of us. We're doing it.
Right.
Let me hit a viewer's comment here. Hannah Davidson asks, she saw this for the first time. Can someone please explain what this is all about?
Mm-hmm.
What Kirk's Law Corner is about, and Kirk can probably explain this better than me, but we're here to just share our knowledge. And on Wednesdays is a call-in show, and you can ask us questions. Chris has been doing this for close to 30 years. Kirk has done tremendous research into the fundamental foundation of our law. And my experience is in federal court holding bad actors accountable. So that's kind of a summary of our experience, and we're here to share knowledge. We're working on a case in the United States Supreme Court, and we're going tens of thousands strong to the Supreme Court with an original jurisdiction case. So I'll shoot a link out here again, and you guys join that if you want reform. But that's what we're about. Kirk, did I call that out right?
I think Kurt went on a smoke break.
No, he's there. He's just muted.
I'm posted over here, posting stuff on.
I'm just giving you crap.
No, you're all right.
Did I say that right? What we're about?
I'll be honest. I originally started Kirk's Law Corner group as a place for me to, as I did my research, to post it in there so that I could go back and write my documents.
Law for dummies.
A bunch of garbage in there. You know, I'm already well aware of the corruption. You know, and if you're in that Kirk's Law Corner group, read the About Me section. Okay, I'm well aware of the corruption. No videos, no memes, nothing about the corruption. This is about law. And so from there, I'm like, well, crap, I'm going to start educating the people. And that came about through Randall Stone. And Randall Stone and I spent 3 hours on the phone. And at the end of the 3 hours of me rattling on my knowledge of what I had at that time, you know, almost 2 years ago now, he's like, you're telling me stuff that I've never heard of. And I talk to attorneys, lawyers, representatives in government, blah, 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 you know. And I'm like, what are you talking about? He's like, I never heard none of that stuff before, particular parts of the law, you know. And he's like, you break it down so grandma can understand it. How would you like to have your own radio show? So I started out on Blog Talk Radio with Future of Our Children with Brian Kinter and Randy Davis, Cheyenne Davis, over there on Blog Talk Radio. Did that for about a year, and I brought in Tony Pellegrino out here, one of my personal friends from American Common Law Academy. We started teaching people about Title 42 lawsuits, how to file lawsuits, because Tony's done a few of them. He's won a couple. So, you know, he's fairly knowledgeable in that area. And I'm just wanting to educate the people on what their rights are, how to claim those rights, how to effectively defend your rights. And then I ran across Chris, and I gave him a bunch of crap. Why ain't you going after the bar? No. He's like, why don't you just read my paperwork? And I'm like, yeah, whatever. You know, why aren't you going after the bar? Well, I finally took the time to sit down and read his paperwork. And I'm like, oh, yeah, you are going. Okay, you're all right, dude. Let's be friends. And then I'm like, hey, you want to come on the show? And then we got to talking about, and I started reading John's stuff. And I'm like, dude, this John guy's pretty rocking. He's got some cool stuff going on. And Chris said, well, you know, I used some of John's work over here in this, da-da-da-da. So I went and I read that, and I'm like, hey, John, want to be friends? Yeah, you want to come on the show? So I basically have been trying to build a team of solid, professional type people that can speak clearly and concisely about whatever it is that they're knowledgeable about. And now the three of us here, including now Ted, of course, basically we've kind of found each other. And Ted's like, hey, you want me to produce your show? And I'm like, wasn't sure that I wanted to go live video type stuff. And Ted does a wonderful job of what he does. John does a wonderful job of what he does. Man, he knows them Supreme Court rules like nobody's business. And he holds their feet to the fire, which is what makes this a great team with what Chris is doing, what John is doing, what Ted is doing, and just my general knowledge of things. I mean, I've been in court battling stuff out for years. So, you know, we each have our own little skill set here. And as a team, we rock it. Plain and simple.
Giving them hell.
That's what we provide.
And in September, we are slated to actually go before committee in Washington, D.C.
And that's on the 12th, correct?
Was it 11th and 12th?
11th and
11th and 12th. As of right now, it's
Right.
As far as I know. Chris and I have been invited. I'm trying to get John in there with us because it'd be great to have the three of us.
So if you don't know, what is that background noise? Where's that coming from? Crystal. So the 8th, which is a Sunday, that's the mother of all rallies. And
Right.
we're hoping to get a huge presence there, because if you remember last year at the Mother of All Rallies, 5 members of Black Lives Matter came there. Somebody spoke, and they got thousands and thousands of views from that speech. I believe Cash Jackson is already slated to speak, and if you'd like to speak, contact Tony Kitely and submit your speech. It's a very professional event, and you can't just go up there and speak. You need to submit a speech. I'm hoping I'll be able to produce some of that. And then the following day, I think is Grandparents' Day, if I'm not mistaken, on the 9th. And that's one of the events that Mark Young, he does Mother's Day, Father's Day, Parents' Day, and Grandparents' Day. And so we'll have that day, and then the following day, I believe, is a march, as well as the 11th, and then the 12th is the full congressional day, which you guys have a big part of. And I know people are still working to put that all together. I'm getting some firsthand information from Tony, and I believe Robert Slavin is one of the people helping Tony directly, and I'm, after the summer, a month before the event, I'm going to start promoting that with a daily show starting in late July. And I'm going to try to produce, while my son is here, I'm going to produce at least one of your shows, guys, and then one show with Tony and Robert, whatever guest or whatever, every week, so we all know exactly what's going on with the September event. There's still a 4th of July event, and if you're in the area, if you can get there, if you can get to both, fantastic. But I think that the main event will be when we are able to talk to legislators. Unfortunately, the Supreme Court is out of session until October 1st. They have a huge summer break from the Thursday before the 4th of July until freaking October 1st. So I'd love to see us switch things around and have an event on like October 1st, even do a sleepover on the Supreme Court steps the day before. So when they come back to work, we're all there waiting to talk to them. That's a dream of mine. But this year, that's really the big event. I mean, it's really a 5-day event. So if you're planning on going, we really all need to work together and figure out accommodations. There's a few people in D.C. who will put us up. There's also a campground close by that was offered to us back in Winnebago.
No.
There's a campsite that was offered to us back in 2016, but the whole family got sick, and then we weren't offered the same thing in 2017. So we need to contact them to get a whole campground and get food like we did in Clarksville and work together. Take care of each other and get through this whole 5 days. It would be incredible if we could do it.
Ted,
So that's enough for me.
My understanding is that we have 2 8-hour blocks.
Right.
The 11th is the first 8-hour block, and it's basically where we're going to come in and we're going to talk to them, and we're going to take turns, and we're going to talk to them about issues within the law, which part of why I want John there is because I would love to bring up this suit.
Oh, yeah.
Go in front of the Supreme Court is the fact that, we don't have a Republican form of government. What we're under is foreign to our form of government and repugnant to the law. And in my part, I'm going to break down the ideology and how a nation is created by law, and what the law actually says as it is written right here, right out of my book. Okay. And so on the next day, the 12th, the next 8-hour block is about questions, but we're supposed to be providing remedies because, you know, you can tell somebody about all the problems all you want, but they're wanting us to supply, same thing that Chris runs into. Well, what do we do? Okay, that's what's going to happen. We're basically going to try and tell them what the problems are and give them solutions in accordance with the law.
Right.
So that it's done lawfully.
And
we're going to tell them how it's done.
Yeah, and I think you guys focusing more on the broader due process legal side of things is going to go over better than saying, like, not to single you out, Jody, but saying repeal the Father, Father Act, or repeal the Violence Against Women Act. There's one broader question that solves all of these band-aids, and that is due process. Once we bring due process back in, and part of due process is to establish jurisdiction. Once you do that, then a lot of these problems solve itself, and all these band-aids that everybody's complaining about, this, that, or the other thing, will kind of fall into place once we get that due process. I agree with John 100%. And the great thing is about your show, guys, is you're not talking about just family law. And when you think outside of the box, that due process really is the foundation where everything went wrong. And I do think that the problems with family court have a lot to do with all the other problems. But if you still stick to a more broader question, like John's one question, as opposed to, maybe 7, 8, however many questions, that one broad question, in answering it, answers all our questions, or at least starts to.
In reality, here it is. Okay, the War of 1812. What happened in the War of 1812? Because we were ratifying the original 13th Amendment, which was the title of Nobility Act. If in reading the Declaration for the Causes and Necessity of Taking Up Arms from July 6, 1775, they talk about admiralty jurisdiction and this ministerial enemy. And by the very, very early 1800s, like around 1803 to 1807, they figured out who this ministerial enemy is. And it's the Crown Temple Bar, the Bar Association. So this is part of what's even in Christopher Hallett's first practitioner's judicial report, is that the bar is a monopoly. But not only that, the Congressional Act in 1845, by extending admiralty jurisdiction back onto the land, that is a repugnant act that was brought into being by Congress that was under coup from 1812, from the War of 1812. And 1814 is when they came in and burnt our Capitol.
Right.
It's the White House. It's the White House now because they painted white to cover up all the charred burn marks on the Capitol from attempting to destroy our records of fully ratifying the original 13th Amendment, which kicked the bar out of our country, out of our nation.
So having all three of you together.
Let me finish this.
That's
when we get into that and we go, admiralty jurisdiction in 1775 was the reason why we took up arms to defend ourselves, is in the Constitution in Article 1, Section 9 and Article 1, Section 10 as bills of attainder and declared acts of tyranny in the Declaration of Independence.
Right.
Okay. Now we've returned back to Christopher Hallett's work, returned to parliamentary practices under admiralty jurisdiction, which affects, and they split. Okay. So the common law, and we go back to American jurisprudence, that marital rights, well, not actually just marital rights, but marital rights and parental rights, okay, those are natural rights. They come from the law of nature. They happen naturally.
They need to
we are
know
a
that.
creation of God in this nation, according to the law that was laid down in 1776.
We create children just like we create appendages or hair. It happens because that's how humans are created. It's a fundamental right.
Of nature, naturally.
Right.
Okay. So from there, we go into American Jurisprudence, Volume 15, Civil Rights Section, Section 2, which specifically says that natural rights and civil rights have nothing to do with the establishment, support, or management of the government. We just fixed the whole entire, not just family court, but criminal court, because here's the reality, okay? There is no lawful authority delegated to government by Constitution that allows them to subvert the common law. We, the people, suits between man and man, as in mankind, okay? Whether you're male or female is irrelevant. We're talking about mankind, okay, is to be heard at the common law. That's why the 7th Amendment reads the way it reads. Suits at the common law exceeding the value of $20, the right to a trial by a jury shall be preserved. And anything heard by a jury, shall not be heard anywhere else because it's already been heard by the jury.
Right. That's, what do you call that? What's the term for that?
Common law.
And it's in our state constitutions as well. Most of the state constitutions say we have the right to a trial by jury, and it doesn't say $20. That $20 in today's money is like $600.
Right.
And this is the question that we're asking, and I think this gets back to Kirk's point. If they come back and they say no, you don't have a right of due process, then they've affirmed that these are in fact admiralty courts, and that and then that brings us back to the assertion that, well, you don't have jurisdiction then.
That's right.
But I think that the Fifth Amendment guarantees us a right of due process in federal courts, and the 14th Amendment, there's that dispute out there about whether the 14th was properly ratified or not. And I don't think we need to get into that argument. We've been following the 14th Amendment for a long time. And so I think we can just assume that it's de facto been ratified, And so the 14th Amendment guarantees us a right of due process against the states. And we're not being provided that. So we're going to ask the Supreme Court that question. Is the state no longer Republican in character because we have no means to address grievances against the state and enforce our right of due process? And like Ted said, that fixes everything. If we can get into court and we can get the Supreme Court to tell the states, because the state judges are not responsible. They cannot handle the responsibility. The power corrupts them, and they cannot handle that responsibility. And so we get the Supreme Court to order them to say, look, guys, when they want a jury because they think screwing them, give them a jury. And if we can win that, all of these other problems, no matter what side you're on, women's rights, father's rights, parental rights, medical kidnapping, it doesn't matter. If you have a jury, at least you got a fighting chance.
Well, okay, so let me plug this last little bit there. Understanding the common law and suits at the common law, okay? Back to the Virginia Declaration of Rights, when I was reading there, you have the right to demand the nature and the cause of action here. At the common law, it's both criminal and civil court. It's about the nature. Was it accidental? Here's one of my analogies that I use, okay? You got a deal between neighbors wanting to build a fence between the two neighbors, right? Well, one guy doesn't want the fence, the other guy does, so he builds the fence anyway. Now, I come home from work and there's ice on my driveway, and I go to turn into my driveway and it's slick, and my truck slides across the driveway and smashes into the fence. Now, is that criminal or is that civil in nature? That is civil in nature. But we still go to court if we can't work it out between the two of us. Hey, man, it was an accident. Yeah, I'll pay for materials if you want to help me fix it back up, or I'll do it myself, But if, that we can't come to that agreement, that's what we're supposed to go in front of the people. We are self-governed. The jury decides guilt. And that's easily decidable because, one, it's over $20. It's going to cost more than $20 of materials to fix the fence. Okay, so the right to a cause of action is there, and the nature is civil in nature. Now, the criminal side would be, I hate your frickin' fence. The driveway isn't slick, and I came home and just ran the hell over the fence because I didn't like it. That's criminal in nature. That's the difference. And it's supposed to be heard in the same court, the same process. It's all about the demand, whether this is criminal or civil. Was it by accident or on purpose? Did I willfully, with malice, do this? No. And if he tries to assert the claim that I did do it criminally with willful and malice, and it's like, well, wait a minute, I'm presenting to the jury, look, there's snow on the ground, my driveway was slick. Yeah, even though I didn't really want the fence there, I didn't mean to do that. Here's pictures of, everybody knows the date and the time. Oh, yeah, we had snow and ice on there, and that's the reason why the right to a speedy trial is there, is so that everybody is well aware of the time frame, what happened, and everything's fresh in everybody's mind. So with that, that's the reason why we're supposed to have common law courts and self-governed, and we take care of our own personal business, private business. It has nothing to do with government, nothing to do with the establishment, support, or management of government. Period. That's the way
here's the best part. And one of the things that we can always do is not only can we reform the government, but we can always further limit the government, right? Because when you read Supreme Court decisions, they always contain the phrases in a limited government, right? So if we come out and make a proposal that we need to further limit government through its practices, right, based on this fiduciary practice that it's already created that we know works, it provides equal representation under the law. And with equal representation under the law, you get equal protections under, equal protections under the law. So, plus it also provides a method and mechanism for us to manage properly the agencies on a civil basis, not a prosecutorial basis, on a civil basis, that if you have an issue that you need to redress your government, and I don't care what the issue is, it could be anything from welfare reform to I got a pothole at the end of my street. Somebody get your butt out here and fix it, right? Whatever the case may be, you'd see that through, you'd go through that, whatever that department is, that agency, whatever, and the fiduciary would send a report directly to that congressional committee for whatever the action is, whatever the redress is, whatever the remedy needs to be. You don't have to go to court to say, hey, fix the pothole at the end of the road. That's stupid. But the way the current system is set up, you literally have to take them to court to sue them to get them to fix the damn road. Well, now they're not going to fix the road because guess what happened? They just realized they spent how many thousands of dollars in litigation that they shouldn't have had to spend.
Well, that's the whole purpose, is the litigation, so these guys can get paid. That's
right.
The thing that I'm about
that's
today.
That's not due process. That's got nothing to do with the process of redress of government. The redress is I got a problem. I need the road fixed because I'm tired of breaking rims and flattening my tires or whatever the hell it is, right?
There's no doubt the primary purpose of our legal system is to generate billable hours so attorneys get paid. They love perjury. They love all the crap that goes on with vicious litigation because it drags this crap out and bankrupts everybody while the attorneys get paid.
Right. So, basically, that's one of the reasons why I don't know if anybody's actually ever read my judicial report, but I always like to start at the beginning. It's titled, the very first section, the title of it is Return to Parliamentary Practices, right? Well, how do we know that? Because Congress has a position there. There's a guy in Congress called the parliamentarian, right? That guy doesn't have any business being in Congress. We threw his ass out of here before the War of 1812. What's he doing there?
What
right?
about that letter that Randy Davis got? I'm the king over here.
Yeah. Gonna do what? Mother? Sorry, couldn't resist. But so anyway, we're back to parliamentary practices because of that idiot sitting there, the parliamentarian sitting in Congress. That guy's got to go. We need somebody in Congress who is familiar with American jurisprudence that includes the proper methodology and management of our inherited emoluments, right? The bar doesn't even want to discuss the word. Why? Because they've been trying to unlawfully adorn them and destroy every word in this son of a bitch since we were dumb enough to let him back in here. So that's why I said, we go back to, the people of the United States Brexited from parliamentary practices of law some 240 years ago. Yet we have come full circle within our judiciary and returned to the same practices and suffrages from which the Constitution was written to prevent. It does not matter what the law intends if no one is practicing the law, in parentheses and underlined, practicing the law as it was written and intended, or even worse, intentionally misrepresenting the law based on the agenda of the ones who stand to benefit from it. And that was where I articulated the conflict of interest between social control versus domestic tranquility. Domestic tranquility is written in the Constitution. Social control isn't. So they're educating our children based on this social control bullshit, which doesn't even exist in law, by the way, which is in direct conflict of interest with domestic tranquility. Now, here's where it gets really ugly. Some of this social control crap, you can thank my older brother for that, because he worked with the private prison system to help them figure out ways to keep criminals from recidivating. So he was instrumental in creating a lot of that shit. So that's how I know where it came from. So, but we used to argue this back and forth. I used to, what's going to happen when they start practicing this crap outside the jail? That'll never happen. Here we are. So,
just a final note I want to make on that, and I know we got to go, Kirk, but when 42 U.S.C. 1983 was enacted, one of the legislators who was for enactment of that legislation, the Supreme Court reiterated this in the case, I think it was Mitchum v. Foster, and he said, Senator Perry said, judges having ears to hear, hear not, and sheriffs having eyes to see not. And we're providing what the several southern states haven't been able to provide for themselves, basically fair due process and a means to enforce our right of due process. And there was another representative, and he said one of the most dangerous things a person can do is seek justice. And guys, is he not right? That is one of the most dangerous things you can do is seek justice, because you get into their trap, and you just seek a simple divorce, or you try to protect the right of your kids, and they just extort you and violate your rights. And Congress tried. They enacted 42 U.S.C. 1983 for us to have a means to enforce our right of due process in federal courts. And the federal courts won't enforce the damn USC. It's like,
yeah,
when are we going to wake up here?
Right.
My guess is a facade.
Congress and demand from the Supreme Court that we have a right of due process. It's guaranteed in our federal and state constitutions, man.
It's a facade, dude.
Yeah.
The Title 42 is a facade because you've done the statistics on it. How many people, percentage-wise, that are pro se litigants have even had their case heard?
Like 1970, somewhere around there.
What's the percentage that they've actually been heard?
Oh, well, right now it's zero.
Okay. So it's a facade. It's to give the semblance of what the appearance that you have the right to due process of law and you have the right to remedies. Oh, there it is, Title 42. There's your remedy. Yeah.
I like what Mako Hayes said. He called it a beautiful guise. It's a perfect disguise.
So the reality is we're supposed to be dragging these guys off of the bench and placing them under arrest and hanging them if you want to know the history and the truth. Okay. This is the reality is we, the people, are self-governed, and we're supposed to be taking care of our private business in the private without governmental interference at the common law.
Let's lynch them.
Written in law. As it is written right there in the Constitution. The 7th Amendment says what it says as it is written. Article 3 says what it says as it is written. And here's the key. Those that are bound by the Constitution, only the Constitution applies to them, right? The people, the Constitution doesn't actually apply to us, the people, because we live at the common law. Plain and simple.
Well,
we're not even supposed to be in Article 3 courts. We're supposed to be in the common law courts, down at the post office, in the back room there. That's where we're supposed to be.
Well, we're going to try to get back there.
On that note, ladies and gentlemen, thank you for tuning in tonight. I know it's a little bit later, but due to me having a job and
okay, church,
right? We're here to have church here tonight. That's my first name. Kirk means church, so
that's right.
Breaking bread with my brothers and sisters out there.
Amen.
Yep.
And guess what I'm doing? I'm providing legal forms.
Knowledge.
And doing drug testing. I have to be careful giving out legal advice on the job, but that's what I'm doing now. So,
knowledge.
John's kicking their ass in the Supreme Court, which is my favorite. I love that, by the way. You just don't even know. That just makes me cry. But
I'm giving them hell on the Sixth Circuit too.
Right?
Testing them out. My final note, I just posted a link. If you guys are not in the group, the people of the United States versus the 50 states, if you want reform, stop whining and stop complaining and start doing something. Join that group and add your name as a co-plaintiff. And we're going to go tens of thousands of people strong, and we're going to demand reform of our state governments and our broken legal system, and start to heal this country. So for the viewers that are on here, click that link. If you're not a member already, ask to join the group. We'll add you. Stand up for yourself for once.
Yep.
And as for me, I'm having fun writing reports, providing for the common defense. This is the shit that I love doing. And you know what? I'm actually enjoying it because it kind of gives me the sense and semblance of actually getting something accomplished after so many years. And you know what? Somebody had to do it. So,
well, God bless you for the work you're doing, Chris. I know you've.
I love you guys, man. You guys are all kicking butt.
I know you've kept out of all of us, you have kept people out of jail, and God bless you for that, Chris.
Mm-hmm.
Hey.
Yeah, I've noticed in some of the recent work that you've done is some of my history, education that I passed on to you. So, and same thing with John. That's when I first started reading John's stuff mixed in with your stuff. So, you're the one that's really making the stuff happen over there, and we're just working behind the scenes, helping provide.
We all need a swamp pack.
Education.
Cross-pollinating.
That's right.
Right. We're working as a team, and that's the way I see the four of us right here. I mean, Ted isn't really doing any legal research, but he's making this happen, making it possible right here. Because watch some of the other shows where Ted wasn't producing, it don't look quite this good, and it doesn't flow quite this well. So we love Ted over there and what he does. Thank you for promoting our show.
That's right, man. We love you to death.
Shows out there during the week. You got Jay Moss's show, the Far From Normal show on Tuesdays, 6 to 8 p.m. Mountain Time, 8 to 10 p.m. Eastern Time. You got Randy Davis out there, Rev It Up on Sundays. Brian Kinters, I don't know if he's still doing the jam there on Friday nights, I think. Blog Talk Radio, Future of Our Children Network.
Restoring Families Internet Radio on Thursdays. They do open mic night. That's actually pretty fun. I won't sing though. So,
yeah, I'm still waiting for an apology from those guys.
huh?
I'm still waiting for an apology for those guys. I was asked to call in on one of their call-in shows back in the infighting days, and they did a very unprofessional job of interviewing me. Just bashed me and bashed me and bashed me. So I have a hard time. I'm still waiting. They lost a lot of viewers that night.
Well,
I'm still waiting for a public apology for that.
Let's not.
Let's do an after show, guys.
We'll let that. Hey, shit happens. We're above all that, right?
Yes, we are.
We are above that.
We're not. Do you have something there to add on the end of this?
Yeah, I don't have time for that. These people here that I work with are busy as hell. They don't have time for that. I mean, not. We do. The only reason we get to come out here is because of what you do to help us behind the scenes, Ted. There's no way I have time for it. There's no way John had or Kirk has time for it. I mean, we're out there literally in the trenches doing this. And, we enjoy it. I know I do. The more I do and the more I get in front of these people and the more I see the light bulbs coming on, it's like, oh my God, they're really starting to completely comprehend the magnitude of never finishing our form and style of government. That's where we went wrong. And I'm just as guilty of it as anybody else. And I'm willing to admit that. That's my fault. Should have done this years ago. So, but that doesn't mean I can't do it now. And that's exactly what I'm doing. So that's how I came to meet all of you guys.
Ed, did you have a last final comment over there?
I just love all y'all guys.
All right, brother.
I'd like
him
to, after he's off Facebook, to keep us up here a little bit. If he can.
Oh, yeah. We can do an after show, sure.
Okay.
Yep. Well, thank you all for tuning in tonight. Like and share, like and follow. If you go in there into the follow section, actually in some of this on the phone there, it even shows to get a notification when we go live over here. So a little bit of a time change due to my work. So we're going to be about an hour later than normal. So we'll be on 7 to 9-ish. And we're working on changing things around. Maybe Monday nights doing some more just straight short clip type stuff, videos of teaching you how to write documents. And Wednesday nights, we're going to keep that the call-in show and educating. So that's a little bit of change in the platform and chime, but we're still Kirk's Law Corner and we're still a team and we're going to help educate. We're going to do what we do.
Absolutely.